Добре дојдовте во Нов Асном. Во последните 2,5 години, Нов Асном, заедно со неколку македонски патриотски здруженија од целиот свет и патриоти македонци од целиот свет, како и македонците од Пиринска Македонија, здружено водеа борба внатре во европските институции, борејќи се за правата за македонците во Пиринска Македонија, каде што имускратен правото за здружување и асоциација, тоест правото да формираат невладени организација и асоциација. Тоа право е потврдено со 14 потврди од Европскиот суд за човекови правда и пред 2 години лансиравме тужба против Бугарија внатре во Европската Комисија. Истата тужба Европската комисија ја разгледа и донесе одлука. Во меѓувреме, фативме адвокат од Адвокатската канцеларија Cambares во Париз, Франција, кој не застапуваше прво во Европската комисија и потоа во Судот за правда во Луксембург. Ова интервју е правено со нашиот адвокат, господин Behillil Bouziane, и во тој контекст сакам да се заблагодарам до сите оние кои има учество во оваа прва правна процедура внатре во Европската унија, каде што ние, заеднички македонците, ја бараа правдата и правдините за кршењето на основните човекови права на нашите во Пиринска Македонија. Голема благодарност на нашиот прв адвокат Благоја Пандовски, благодарност до Светскиот македонски конгрес Канада, Боби Темелков, голема благодарност до Бил Николов од Македонскиот комитет за човекови права од Торонто, како и нашите од анонимни поддржаватели кои се од Германија, Австралија и Симон Поповски од Лондон. Исто така сакам да се заблагодарам до Македонскиот човеков комитет за човекови права од Нью Джерси и Нью Йорк, кој беше спремен исто така да влета во целата оваа правна приказна и која даде својата поддршка. Ке ве молам, проследете го интервјуто и одлуката од Судот за правда во Луксембург, која ја споделува нашиот адвокат, господинот Бузен, а вие ексклузивно имате за прв пат да ја проследите на нашиот канал Нов Асном. Благодарам. Dear Bouziane, thank you for accepting my invitation for this Zoom meeting. I greatly appreciate your work that you have done thus far for our people, organization, and the cause, the Macedonian cause. This is a just cause that we are fighting for, and you did a great job so far. I'm just going to briefly introduce our audience that you did file a lawsuit against the European Commission and Bulgaria for infringement of EU laws, several treaties, Treaty of Functions of the European Union, and especially Article 12, Freedom of Association and Assembly, which is the fundamental rights of the citizens of the European Commission. We did make the launch, I believe, on 24th of March this year. Can you please tell us what was the basis of the lawsuit against Bulgaria and European Commission?
So, as you know, the place of the Macedonian people in Bulgaria is denied.
Yes.
Fundamentally denied by the Bulgarian authorities on a particular point. It means that the Bulgarian authority and government have the feeling that by the recognition of the Macedonian entity, minority, it could break the whole harmony of Bulgaria. So there is a denial of minorities right in Bulgaria.
There's a persistent and consistent discrimination against the Macedonian minority.
It's the way by which Bulgaria is acting is fundamentally discriminating Macedonian people living in Bulgaria, having their own culture, their own identity, without troubling the whole state and the majority. So you tried several times before the European Human Rights Court to obtain this recognition. The court, the European Court of Human Rights, rendered a lot of decisions condemning Bulgaria for these infringements, for this violation of Article 12, and it's a question of symbol now, and the way Bulgaria acts is very dogmatic. This is not anymore a country respecting freedom of association regarding to the position of the Macedonian people, and all the decisions you obtained from the European Human Rights Court were not executed, performed, and as a matter of fact are not unforeseeable. That means that we thought that by suing Bulgaria before the European Commission, it could help Bulgaria to understand that you did not stay and accept the situation. So we asked the European Commission to look at the way Bulgaria acts against the Macedonian and regarding to the violation of Article 12 you already quoted. The possibility for the European Commission to sanction, to punish on a financial plan Bulgaria because of the violation of Article 12 was our idea. So we wrote several letters to the Commission, and we obtained, unfortunately, a negative position of the Commission. This is why we sued the Commission before the European Tribunal in Luxemburg. And after 6 months of proceedings, we received the confirmation that the Commission was able to refuse its help by sanctioning on a financial plan Bulgaria. And what the court, European Court, said is that it is not her or his jurisdiction to solve the question we asked to the Commission, which refused to sanction Bulgaria. So now the question the problem we are facing is, what can we do now with the denial of the Macedonian people and your association especially rights? I think we might sue the government, Bulgarian government, before the Bulgarian courts. This is the next step. And this is what I am advising, because we should not stay like that, because it will erase, if we don't move, it will erase the Macedonian rights. So this is now the item the item we are thinking about, and I think that we might take a decision all together to continue the action and to get support from all the Macedonian, maybe a neighbor state, which could help through association, through foundation, through non-governmental organization, by supporting our actions and helping the Macedonian minority in Bulgaria to obtain the minimum of recognition. It means to fight against what is totally not acceptable, a permanent discrimination.
Yes. And what was the finding of the court? What was the reason the court denied our lawsuit against the European Commission, as well as the Bulgarian state? You did state in the lawsuit that according to the Article 265, paragraph 1, any natural person may apply to the Court of Justice of the European Union for declaration of failure to act if he or she finds the union body has infringed treaties. And pursuant to paragraph 2, same article, the applicants first invite the body in question to take action. You did take the action. There was no answer from the European Commission. And based on the Article 256, it gave us actually a right to approach the court of first instance, which has jurisdiction to hear and determine at first instance the action referred to the Article 265. Now, that looked very relevant and applicable in our case. However, it's really the findings of the court tell us something else, which definitely continued with the policy. It's basically, it's citing the policy of discrimination, failure to act, and the failure to follow the rule of law, which is very clear.
Yeah, for sure. I think that all this matter, all this concern is about politics. The EU Commission doesn't want to intervene in this matter.
Obviously, yes.
Obviously. And this is what the EU answered in its decision rendered October 16th, 23, by which for a certain numbers of articles, Article 6 of the treaty on the functioning of European Union, Article 167, on these two grounds, which these decision provides that the Union shall contribute to the flowering of the cultures of the member states while respecting their national and regional diversity. On these two articles, which were the basis of our action, the jurisdiction, the court said that unfortunately, it is impossible for the Commission to intervene and to push Bulgaria to respect these articles, which is because it's not a matter of European law. This is what, in a confusion, what the Commission answered, and I shall read.
Yes, please.
The answer of the Commission. I have to inform you that it is not possible for the European Commission to follow up on the matter raised in your complaint. In such cases, it is for Bulgaria, including their judicial authorities, to ensure that fundamental rights are effectively respected and protected in accordance with their national legislation and international human rights obligations, including the rights or freedoms guaranteed by the European Convention on Human Rights. That means that the Commission invites us and invited us to sue Bulgaria before the national tribunals. That means that we should go before the Bulgarian judge and ask him to withdraw. Maybe I'm not really optimistic, but we should do it. We should do it because this is the only way. And this is what the European Court confirmed, unfortunately, that the European Court has no jurisdiction on this matter. So we need to go before the Bulgarian.
What are the reasons for not having jurisdiction of that matter?
Because they consider it's a sovereign matter.
Mm-hmm.
This is a sovereign, that means this is a state member sovereignty and jurisdiction. That means that European cannot interfere in this matter. And this is why now we are facing a difficulty which could be regarded as a wall for us, but we should climb it and jump.
Yes, over the wall.
To get to the Bulgarian judges.
Mm-hmm. And what is the impact on the Treaty of Function of the European Union, fundamental rights of the citizens of the European Union, and Article 12? What is the impact on those articles that this decision that the court has sided with the European Commission?
The European Court has made a distinction between these provisions, Article 12 and others.
Yeah.
This is human rights provisions, which is a jurisdiction of the Human Rights Court, European Human Rights Court, and the national authorities. That's one part of the game.
Okay.
And the second part of the game is the concern of the European Commission and the European, economic jurisdiction in Luxembourg is only about the treaty, but not concerning the human rights. So the consequence of the decision is clearly an exclusion of jurisdiction of the European Court on these matters.
Mm-hmm.
This is problematic. And that means that we should go before the Bulgarian judicial authorities to demonstrate that this way is a U-turn, is impossible. We should demonstrate what the European Court decided is impossible.
And once we demonstrate, because they've been
and then we will come back to the court
then
to tell them that, okay, we tried. Look, we will waste, unfortunately, I think 1 or 2 years.
Yeah.
But anyway, we will have the opportunity to demonstrate that we are in a very difficult position because we are not in the capacity to enforce the European Human Rights Court decision on one side, and that we cannot obtain from the EU Commission the financial sanction of a state member which does not enforce judicial decisions. which have to be respected. And this is a breach of democracy admitted by the Commission. So we should go to the Bulgarian judicial authorities quickly, very quickly, and to demonstrate what we did, and to prove that we tried, and now we have only our natural judge is the Bulgarian, and we expect from him to decide to ensure the Macedonian minority rights and the capacity of Obasham and other associations, minorities association, to represent and to develop a singular, a particular, identical culture. In the middle of Bulgaria.
Yeah, that would be interesting. Now, let's say we do that and make an assumption here. We do that, we go to run around, the Bulgaria court accepts the lawsuit, rejects it, then we go to the second-hand court, which would again reject as it has done in the past. What are do we have an option then? To go back to the
European Commission.
Yeah.
Go back to the European Commission and to the European Court. And then we will ask them, what can we do? What can we do now? I know it seems difficult.
Yeah.
But I think it's a long way battle.
Absolutely.
We're talking about 5-10 years.
Well,
I'm sorry, but we will be old people, maybe old, but it's a long way defending a minority, and especially in Bulgaria, which is a country facing corruption, a certain form of illiberal way of thinking, which is more closer than other state members to Russia. We know that there are links, and they are not totally clear on this matter, and they have taken a position regarding to the Ukrainian-Russian war, which is not really clear. That means that there's a big problem, not only about Macedonian minority rights, but about how democracy functions in Bulgaria. Yes. Is it still working as we consider democracy should work? And this is a main question, and this is a concern of all the state members. But you know, we should stay fighting, because there is a fundamental question, which is the hypocrisy of all other state members regarding to Bulgaria and the way it works. And we have the same position with toward Hungary also. So we need to stay focused on the matter, acting, being realistic about what we can obtain quickly or not, and stay fighting and focused on the matter.
Okay. And what does this tell you about the European Union as a whole, which has these fine articles, infringement article, Charter of Fundamental Rights of the European Union, Treaty of Functioning of European Union, and all these beautiful written letters and law that it seems to me it doesn't function?
This is what I think. I think that it works, but not in Bulgaria. Sorry. Really, I know you're quite disappointed by my answer, but it works everywhere, but not in certain. In the middle of Bulgaria, there's no treaty. Nobody reads it.
Absolutely. And you know, we haven't touched Greece. And I haven't introduced with the problems in Macedonia in Greece, which
Yeah.
are absolutely equal. They're denied any freedom of association only on the basis of being Macedonian. And we thought that by having 14 cases again with the European Court of Human Rights is a good base to launch infringement of EU procedure within the European Commission, and thus having a having a judicial resolve. That's what we were looking for, the rule of law.
But you already obtained before the European Human Rights.
Yes, but
it's paper. It's paper.
Exactly. There is no enforcement.
It's paper.
Yes.
And this is the question and the problem we are facing. It's only paper, and it doesn't really help. It doesn't really help. So we should stay working hard on the matter.
Absolutely.
And I'm just doing something because I would like to read the motivation of the court.
Yes.
Let me.
Absolutely. Go ahead.
The motivation, I'm translating the decision in English so that it will be perfectly understood by everyone. Let me try. Sorry.
Yeah, no worry. I just would like to remind our audience that since you're based in Paris, that the lawsuit was written in French. So now you need to read in French and then you translate.
I can read it in English and translate it, but it will not. Let me try. Très bien. No, not in French. That's actually this one. So what the court decided. So we received from the court July 24 this year a decision, a negative decision from the sixth chamber of the court, by which the judge, a Spanish guy, a Danish judge, and Zilgalvsvit, maybe a Lithuanian or Serbian judge, we received an answer by which the court said that the court considered that it had sufficient information on the case file and decided to rule without continuing the proceedings. That means that they made their view on our documents. So they could manifestly rule quickly on the matter, and they examine what were the grounds of our action. And the decision were we capable to bring an action for failure to act against Bulgaria? And according to the case law, said the court, an action for failure to act may be brought not only against a failure to adopt an act producing binding legal effects of such a kind as to affect the interest of the applicant, I mean you, us, by bringing about a substantial change in his legal position, but also against a failure to adopt a preparatory act if it constitutes the necessary precondition for the conduct of a proceeding intended to lead to an act producing binding legal effects. That means that we were regarded by the court as receivable, and our complaint for failure to act against Bulgaria was received and accepted and admitted. That was a good point.
Yes.
But unfortunately, the judge decided that it must be noted, however, that none of the measures which the applicant requested the commissions to take in the context of the complaint referred to a question asked by us can be classified as an act producing binding legal effects capable of affecting its interest by significantly altering its legal position, or as an act constituting the necessary precondition for the conduct of a proceeding. The measures which the Commission could have taken would have been addressed solely to the Republic of Bulgaria and not to the applicants. And the procedure initiated to that end could only have led to the adoptions of acts producing binding legal effects in respect of that member state. To resume,
Yes.
to summarize
Yes.
this answer, the court considered that we are right and we were right to sue Bulgaria, and to ask the Commission to act. But what the court says is that we, as an association of people, could not ask directly the Commission to act against Bulgaria.
Who has
what the court says, it should be the Commission's jurisdiction to act. That means that the only authority enabled to act is the Commission by itself.
But the Commission has withdrawn its responsibility.
And we know that the Commission is not moving, is not acting at all. That means that everything is blocked at the Commission stage. And the court says it follows that the first head of claim of the applicant seeking in substance a declaration that the Commission had failed to fulfill its obligations under Article 317 TFEU must be rejected as manifestly inadmissible. It follows from all the foregoing that the action must be dismissed in its entirety, in part on the ground that the court of first instance manifestly lacks jurisdiction to hear it, and in part as being manifestly inadmissible. That means that the court answered negatively, refused to appreciate the failure of the Commission, reproaching to your association the right to ask directly the Commission to act against the Republic of Bulgaria.
Yes.
And this is problematic because it means that it's the dog trying to eat himself, you know, turning. We have and we should go before the Bulgarian judicial authorities. Yeah.
Okay. No, that's a path for moving forward. Of course, it will give us a big time-wise run around. However, based on what you're saying, that maybe in the second chance, the European, not Commission, but I would say the Court of Justice would accept our arguments. And for the sake of the argument, just to clarify, under the Article 317 of Treaty of Functioning of the European Union, the Commission, the Commission shall implement the budget in cooperation with the member states, and that means that they shall cooperate to ensure appropriations are used in accordance with the principles of sound financial management. So the regulations lays down the control and audit obligations of the member states in the implementation of the budget and the resulting responsibilities. We did ask to withhold the budget funds until from the European Commission Cohesion Fund until the Bulgarian state registered the Macedonian Club for Ethnic Tolerance, and that was unfortunately rejected. Okay, so this was very revealing. It's a very big learning experience. It's the first judicial case of this kind that the Macedonians have launched within the European Commission, not just that the European institutions. Thus far, only the European Commission of Human Rights, which is under the umbrella of the European Council, has looked at these cases. But this was the very first judicial case that we get our feet wet and see how where we stand, where they stand, what are the pluses and the negatives. The fight must continue for the human rights. This is generational issues, as you pointed out. By the end of the day, we might be very old till we get the second, third, etc. But definitely, we do have to continue. As of now, Macedonians in Greece and especially in Bulgaria do not the basic human rights guaranteed by the citizens of the European Union. And this judgment just confirmed that there is no judicial authority to resolve their human rights violations.
For the moment.
For the moment.
Absolutely. That means that we should stay focused on the matter and stay fighting.
Absolutely.
Because there's no conceivable future to understand what the European Court said. This is an impossible way of thinking. It should move.
Absolutely.
Sure. That means that we should stay focused. Sasho, I sent you the translation in English of the decision. Excellent. So that you can spread it everywhere.
Absolutely.
To let the people know and the journalists, to let them know that this is not acceptable to stay like such. We are in impossible future.
Absolutely. I greatly appreciate your time, your help. You've done a great job thus far. You've been a great light source in these dark Macedonian times for the Macedonians in Bulgaria, and I really thank you for giving us encouragement and the words that we need to stay focused and fight. That's the only way, a path forward for us, because it is unacceptable a discrimination within the European Union to be norm rather than an exception, unfortunately.
Macedonian life and way of thinking matters.
Absolutely. I do think so too. It does matter, and I promise that we will continue the fight. I'm going to go back to my Macedonian friends in Bulgaria and
me
let them know where we stand and encourage them to follow your advice and take the next step forward. In the meantime, I will be inform you along the path where we stand, how do we proceed. So I hope in the future we can have the second round of judicial fight within the European Court of Justice.
For sure.
Absolutely. Dear Bouziane, thank you very much for taking the time to speak to us and to our followers and the Macedonian public. We will keep in touch and we will inform our Macedonian public of the next steps. Thank you and have a great day.
Bye-bye, guys.
Bye.